If you were there, would you have taken all the knives?
I think seeing the picture that we saw earlier, seeing the one knife that was backwards, I probably would have done the same thing as her. The other knives were underneath other things. It wouldn't have made a whole lot of sense that that would have been the knife that would have been placed on top of a drawer of an incident that took place right after. It's not like multiple people have gone back and forth to that particular drawer and moved it. The scene was secured.
So you'd rather limit your investigation and limit the data as opposed to look at everything? Right?
No, I go with what appears to be what it is. If something's out of place, to me that's something
Let me ask you a question.
Let him answer, please.
If it's something that looks out of place, then I would focus my attention possibly on that particular item versus collecting knives from everywhere in that particular
But listen, this is a loose drawer, right? This is a loose drawer. It's not like the, pardon me? Referring to State's Exhibit 103, it's not like this, where they're all tidy and put. You've seen this, correct, Detective?
Yes, I have.
It's not like this drawer, where the knives are neatly put in segmented areas. It's a loose drawer, correct?
Yes.
Correct. And so you don't know if somebody opened a drawer and closed it, and then opened it again and closed it. You don't know how many times that drawer was opened and closed, do you?
No, based on the statement.
But
Let him answer the question, please.
Based on the statement that the defendant provided, he disarms his wife, Jennifer, places the knife in the drawer, and closes it. At no time does he say, I open the drawer 5 more times and close it 5 more times.
I'm not talking about Derek interrupting the witness.
Sustained.
I'm not talking about Derek. I'm talking about your team. I'm talking about officers that got on the scene, opening and closing before they were told what to look for. So you have no idea how many people went rambling through that kitchen before that photograph was taken, right? You don't know. Nobody knows. Right?
It's not common for us to go through kitchen drawers and go crazy through kitchen drawers.
You're telling me
You may finish your answer.
I've notified Detective Medeiros very early on with regards to that particular knife.
So you're telling me with regards to the fact that my client's first statement to the South Miami Police Station was the fact that there was a knife involved, that people wouldn't potentially be looking for a knife, and if they open a drawer or close drawer, you don't have any of that information, correct?
Well, sir, the search warrant was obtained several hours later, so we wouldn't have gone through drawers initially because the scene was secured at that time.
How do you know? You weren't there.
Because the scene was secured, that's how I know. So the scene would have been entered at the time that Detective Medeiros executed that search warrant. And if you'd like, I can give you the exact time.
Absolutely. Give me the exact time. Give me the exact time.
At approximately 8:45, or I'm sorry, at 8:45, the signed search warrant arrived at the house. So they would have had, she would have had that knowledge prior to that.
So can you tell me how many people were in that kitchen and searched that kitchen prior to this photograph being taken?
Detective Medeiros, okay, would probably be able to answer that question. I wasn't there at the onset of the search warrant.
Respectfully, Detective Grossman, I'm not asking about Detective Medeiros. I'm asking you as the lead detective in this case. Let me ask you a question. The video surveillance, was that running while you guys were conducting your investigation?
No.
What? It wasn't running? Why not? So hold on, let me get this straight.
Well, can I finish my answer?
I asked if it was, yeah, go ahead.
No. When the search warrant was signed and it arrived on the scene at 8:47 p.m., digital forensics and video forensics entered the residence to retrieve that footage.
And under whose direction was it that the first law enforcement group to go into the house was that group? Was that under your direction?
Detective Medeiros.
Okay. And so Detective Medeiros, in essence, ordered this group of officers to go in and shut off the DVR before you guys conducted your investigation?
We were trying to get the footage of the incident, so yes.
Why? You didn't ask my client about it. Why was it necessary to get it right then? Why?
Because that's the decision that was made at the time.
By who?
Detective Medeiros previously said that.
So that decision means that we here as people in this courtroom, members of this jury, yourself, myself, the judge, the prosecutors, can't see how many people walk in and out of the courtroom. Correct?
Correct?
When did you first view the surveillance?
Would have been the morning of August 9th, 2013.
What time?
My report indicates at 11:15 a.m. that Detective Nick Pimentel provided me with the DVD copies from Detective Ruano from our video forensics unit.
And what time did you guys leave the house that night? Did your team, everybody, who's the last person out at the incident location?
We were all there at the incident location, so we all left and we released the home to the defendant's father, Derek Ian Medina, at approximately 3:55 in the morning.
So, just so I have this clear, Detective Medeiros orders members of law enforcement to cut off the video surveillance first, right?
Correct.
And during your investigation of the home, none of that is memorialized, and you did not view it until the following morning around 11, correct?
That's correct.
His statement, the formal statement, so you was concluded at 7:22, correct, Detective? Or
7:23.
My bad. So the information with regards, the statements with regards to narcotics happened before you guys went inside the house, correct?
Correct.
Did you inform anybody in your crime scene team that they should potentially keep an eye out for narcotics at the house?
I verbatim said that. I don't recall saying that verbatim. I mean, usually if we see something in the obvious, then yes, we take it.
Well, you'll agree with me that you guys looked for a knife because he told you there was a knife, correct?
Correct.
He also told you that she'd used drugs, but you didn't look for drugs, correct?
He said she used to, so
Okay, well, used to could have been that morning, correct? You don't know. You didn't ask follow-up questions, did you?
no.
Okay. So you don't know what used to means, correct?
The way I interpreted his comment to me was in the past.
Okay. Well, I appreciate the fact that you interpreted it that way, but you didn't ask any follow-up questions to clarify it, did you?
No.
At some point, you received a call from my office, correct?
What day are you referring to?
I'm referring to about a month or so after this situation. You received a call that my investigation had recovered something at the house. Sidebar.
Sustained. Okay, let's come sidebar.
so just to clarify here, Detective, no drugs were impounded as a result of your investigation on August 8th, 2013 at 5555 Southwest 67th Avenue, correct?
Correct.
Now, I want to go back to let me find my notes, I apologize. There they are. Going back to the pre-interview, what you guys call the pre-interview. Did you have any conversations with my client with regards to his marriage? And that's kind of a long question. Let me rephrase it. Did you ask him if they... Sorry, just got stuck for a second. Did you ever ask him what caused them to have their initial divorce?
Not that I recall.
Would it be fair to say, and I know that my client says it a few times in his statement, as well as making several statements to initial officers, that there was some sort of abuse allegation that my client was laying, correct?
Correct.
Did you find any writings in the home from my client that would suggest that he had the intention to harm the decedent, Jennifer Alfonso in this case?
No.
Did you find any messages, or any messages, and by messages I mean text messages, Facebook, WhatsApp, any kind of electronic message medium where my client showed an intention to commit harm to Jennifer Alfonso?
No.
Did you find any writings in the house which showed that Jennifer Alfonso had an intention to commit harm to my client?
Objection, relevance, motion limiting.
Sustained.
Did you find any electronic medium? Well, let me ask you this. Did you learn of communication between Jennifer Alfonso and Kelly Berry the morning of the incident?
Objection, hearsay.
Sustained.
Judge, I'm asking if you just simply...
Sustained.
Judge, can we come sidebar, please? Thank you.
Please be seated, everyone. Detective, if you could kindly step into the jury room for me for a moment.
Are those pictures there evidence on your table? I got them.
We would never do that.
I thank you. I appreciate it. I appreciate you helping me out. You really don't sit down in the corner.
Yeah.
In that corner over there. In the back.
I just want to be able to have them in front of me. When you get them, put them up here so I can review them, so whatever argument I make it to the judges.
Okay, State, would you mark this just as an exhibit at this point so that if it becomes an issue on appeal that there's something that an appellate court can review?
Yeah.
Okay?
Okay.
So I'll ask Deborah to do that.
Do you want to back this?
And then I'll...
Could I just check out what you want to take? No, I want to take the sticky off.
Well, that's the sticky I just put on.
Oh, you just put it, oh, I'm sorry.
I just did that.
I don't want my sticky on.
And I'll take it off. I just put it there tomorrow.
I'm sorry, Judge.
Judge, this is what I'll say with
Okay.
regards to that. Throughout the conversation that the decedent has with Kelly Berry, the morning of, hours preceding the actual incident, she discusses multiple positions of anger, where she talks about ripping off my client's face, substantial disappointment, angry feelings, and at the end, feeling about ready to explode. These are all in our position statements which suggest that she's clearly under the excitement or the anger. She's still steaming from the issue of not being woken up at 1:30 in the morning.
Ms. Klein, can I see this?
I'm sorry.
Get it to me. Yes.
Okay, and for the record, it's just been marked as State 9-0. Okay, I read this very differently. First of all, I think if the defense is attempting to use what is now marked for identification as States 9-0, I read it very differently. First of all, you have just a foundational issue. Yes, it says Jennifer Alfonso at the top of this, but I could pick up anybody's phone and I could pick up my husband's phone any morning and use his text messaging machine, and it'll come up as his phone number. That's number one. Number two, for an excited utterance, it needs to be in reaction to a startling event. She's upset because she was not woken. She's upset because of the absence of an event. That's number one. Number two, in this communication with somebody who it does not indicate who she's communicating with on the document that I'm looking at,
It does, Judge.
it indicates,
It shows recipient Kelly Berry, author.
not on the document I'm looking at.
The
Okay?
documents.
So, but regardless, even if it said Miss Berry, it is clear from this conversation, assuming it's Miss Alfonso, that she outlines what did not happen that made her upset. They talk about it, which indicates that she has time for reflection. Then she indicates, then there's a period where whoever she's communicating with it, assuming Miss Berry, where Miss Alfonso indicates, it's okay, I should trust him enough. And Miss Berry responds, I was bleaching the shower, sorry. So no, I can't tell from this document.
Where are you, Judge? Can you direct me again, please?
You can come look over my shoulder, but it doesn't have page numbers, the document I'm looking at. It says, I was bleaching the shower, sorry. So it indicates that time has elapsed, which would go against an argument of excited utterance. She continues, then she starts talking about, I need bleach. So clearly she's no longer under the excitement because now she's talking about an unrelated issue that she needs to get bleach for some purpose. Then she re-excites herself by saying, I just want to spend time with him, but I'm not going to beg. Then the person she's talking to, apparently Miss Berry, starts talking about buying a Rolex. They begin talking about, again, about the incident that occurred. Again, it doesn't say when the incident occurred or how long this conversation is lasting between allegedly Miss Alfonso and Miss Berry.
Because what you have there is...
Wait, I'm not done. And then it says, I felt like ripping his face off an hour ago, which shows that she has had time for reflection. She has calmed down. She does not say, I still feel like ripping his face off. She refers to ripping his face off an hour ago. And then they go back to cleaning again and having a burst of, then apparently Miss Berry has had a burst of energy. So again, she's had time to think about something else. Then they start talking about working. Thursdays are money days. Then they start talking about listening to a song on Pandora. Talking about Issa being asleep. Talking about Miss Berry's reaction to bleaching her shower. Then it goes on to say Miss Alfonso responds, I'm bored, which indicates that she's no longer under the excitement. She said, I tried meditating, but I don't know. So clearly she's had time for reflection. Then apparently there's a statement that Mr. Medina comes into the room without saying anything. She indicates, I'm going to jump into the shower, okay? I need to calm down because I feel like I'm about to explode. And then she says, I feel better.
Well, Judge, with regards to that last statement where Mr. Medina comes in the room and she makes a statement, I feel like I'm about ready to explode, that's clearly her reaction after seeing my client and indicates her excitement at that point. That clearly falls under the auspice of an excited utterance. That my client walked into the room and as a result of him coming into the room, the simple sight of him made her want to explode. I believe that is a classic excited utterance. I believe I should be able to utilize that one specific statement. If you don't want me to get the whole thing in, that's fine. But based on the court's own reading, Miss Alfonso went through a slew of emotions and this, that, and the other, but she specifically says, I feel like her last statement clearly shows that that my client entering the room.
I'm not going to permit it as an excited utterance because she says in this, I need to calm down because I feel like I'm about to explode. The person she's communicating with says, oh, no, don't, and there's an emoji. Says, I know, I feel better. The person responds, showers help. And then she starts talking about things in the past tense. This is not, according to this court, an excited utterance. I'm not letting you get it in through this witness.
Judge, that would be over defense objection. I believe the court does not have what this defense has, which is time-stamped communication, which would show that she feels better after she takes a shower, which means that there's a pause between those two statements. So when she makes the statement with regard to about being ready to explode, there's then there's a period of time between that statement and the other statement. I believe the secondary statement absolutely does not fall under excited utterance. But the fact that it's the defense's position that she clearly says, as a result of after seeing my client, I feel like I'm getting ready to explode, the defense's position is it is an excited utterance, and we object to the court's ruling.
Okay, the court's ruling will maintain.
And Judge, for the record, the state's other objection to preserve it is that we don't believe Detective Grossman could even authenticate this, even if it were excited utterance. We believe Ms. Barrett herself is the only witness who could authenticate it, even if there were a hearsay objection.
And that was the first thing I had stated in my ruling.
Correct, Judge, and this is what I would ask the court to do at this time. Given the fact that we don't know exactly what Ms. Berry's situation is, we'd ask to be able to perpetuate her testimony tomorrow. Judge,
Do we have contact with her? And it's up to you all to set it up.
They did indicate that they were going to talk to her after lunch, and I will say this, Judge, I'm growing more and more concerned that Ms. Berry is suddenly going to not be able to proffer testimony, and then my client's going to be in a situation where these relevant statements made by the decedent are not going to be admissible. The jury's not going to have a full picture of her emotional state that morning, which goes part and parcel with our defense, and I would ask the court to order her testimony to be perpetuated tomorrow in the morning. Myself or Mr. Padilla or Mr. Yaber will be able we're available anytime, 24 hours a day, 7 days a week.
Okay, well,
So Judge, if I may.
Please.
So I did have communication with Ms. Berry, and as of now, her doctor has cleared her. She is good to go. Again, I don't know what's going to happen. She's 2 centimeters dilated. I don't know. I would be in agreement with the court. I think we would be in agreement with the court's suggestion that we perpetuate. That's fine, so that I guess either party could use it whenever they want. However, for that to happen, I have already asked, because the court sort of threw it out there, I've already asked our people to look into where's the closest site. I believe it's 27 miles from home, and ask them to confirm availability for tomorrow. They're working on that as we speak. However, defense's suggestion that Mr. Padilla or Mr. Yaber would be doing it is something that the state would object to. If we perpetuate, we perpetuate here.
We perpetuate
and if we are
right here.
in trial, exactly, the jury can take a break, but everybody has to be here because that's what would be used for an appellate record, would be as if she would be here.
I would agree.
I'm sorry, Judge. I misunderstood what the court's instruction was on perpetuating. If it's an open court, that's actually better for us.
Okay, so let us know what you're learning.
Fine.
Okay?
Judge.
Mr. Dunn, can you go retrieve the detective? Yes.
I have a 2-minute bathroom break. I'll be back in a minute, 30 seconds.
You can go use the one in the jury room, just swap places.
Let me put this chocolate. Yeah, put it in the middle. She's sitting out. Me too. She be looking out for us. This is all chocolate. Oh gosh. They are good. It's like heaven. Well, you know we was late. I know. It's his fault. Yeah, it's his fault.
And I'm going to ask members of the media, please make sure that our sidebars remain our private affair, please. As soon as the governor is back.
I know, all day.
Thank you, Judge.
Thank you. Okay, let's bring in the jury.
So good.
Yes.
Yes, you do.
She said the chocolate butter.
Oh, it's good.
I have no idea what she's talking about.
Oh, it's like heaven. Good. When her birthday, we gotta do something for her. We gotta find out when her birthday. Right, ask her. When is Nikki's birthday? When is Nikki's birthday? Did it pass already? January. Okay. We got this.
Thank you.
Please rise.